Drew Larian, the head gardener at the Barnes Foundation's horticulture program in Lower Merion, Pennsylvania, was about to take us outside to identify the weeds we had just studied. He'd stumped us earlier in the lecture when he asked us what the definition of a weed was. Finally, he clarified it for us. A weed is simply a plant out of place, like a dandelion in the middle of your front yard. Over the last 6 years, I've been formally studying horticulture while continuing my work as an attorney, recruiter, and career counselor. I'm enthusiastic to share some of my thoughts today based on my work on attorney professional identity and practice area with a botany twist. My basic premise is that law schools should implement curriculum for a new field of study called legal occupational design, using principles of what I call legal taxonomy. Educators need to understand their role as curators of their students' future beyond the confines of a traditional legal education. So who is Carl Linnaeus, and why am I talking about him this afternoon? Linnaeus was an 18th century Swedish natural scientist and physician who preached the majesty and necessity of the empirical study of the natural world. His work embodies a principle as an observer and describer of objects of the senses that nothing exists in the intellect that does not previously exist in the senses. Linnaeus simplified what were long, confusing, distracting, almost mystifying names of plants. He said, we can never hope for a lasting peace and better times till botanists come to an agreement amongst themselves about the fixed laws in accordance with which judgment can be pronounced on names. As an example, tomatoes went from a long, confusing name to a clear, simple identity. A family of plants first, then a scientific name consisting of two parts, a genus, then a specific epithet or species written second. In the plant world, Carl looked for similarities between family, genus, and species of plants to deduce their binomial nomenclature. Family is defined in botany as sharing a common attribute. One giveaway for the mint family, Lamiaceae, is that all plants in this family have square stems. Genus is a group of similar related plants with common characteristics. Species comes next. You may have very similar plants in the same family and genus, but they do not share all traits. When we think about our lawyer family, we can look to results noted by organizations such as NALP, tracking JDs on their career launch. We measure these outcomes to see a student's career path after the fact. We know today that about 40% of JDs don't pass a bar exam, but they are still working in some capacity. A legal occupational design course provides a realistic study for each law school unto itself. This course of study lies in the hands of the curators of the students, a law school's legal educators who can develop and refine curriculum in this field. A program such as I am proposing stands alongside contracts and torts. Such a course introduces the student to the empirical aspects of the actual legal practice areas and some self-study. Students study the economic and result-driven outcomes of their choices and learn what clients both empirically and philosophically seek through legal representation. Students may handwrite some of their papers in this course as a connective exercise. Law students dig into the theoretical aspects of past, present, and future practice areas and their own core strengths. They wonder and create for themselves a preferred client base, and they can deconstruct that client base to understand the nature of their choices. In landscape design terms, they're conducting the first step of the design process, their own career pre-design, which includes determining program goals, site survey, site analysis, and site research. Two leading voices in today's ecological landscape design, Thomas Rainier and Claudia West, promote designing plant communities for resilient and diverse landscapes. The book is fantastic. Likewise, resilience and diversity are two major traits for the future attorneys that you are educating. Regarding the client side of this area of study, one New York law firm recently posted a job for an associate to join the firm's film and entertainment finance lawyers in its finance practice to work on deals. But labeling problems erupt when you cross-reference this job description with the firm's own practice area descriptions. There are no defined film and entertainment lawyers on the firm's website. There is no simple finance practice. In fact, there is no entertainment practice listed on the website. In client terms, it seems in 2017 that for attorney practice areas, the tail is wagging the dog. How does a JD navigate their career without the tools to know what they seek, as much as what a client or boss will demand of them from actual day-to-day legal work? Some law school career offices have created online dichotomous keys to direct law students toward their potential career path. While these tools can be interesting, they seem limited in some ways. Each law school funnels its students down a preset path depending on the school's size, ranking, and location as examples. Your law school becomes part of your genus. While attending law school, it is an educator's job to not only get the student prepared to pass the bar exam, but to provide its professionals with the tools to thrive in the soil into which they are planted. Linnaeus' work occurred over 250 years ago and is still used today. Maybe it's time to leverage our collective knowledge to create legal curriculum to include coursework on legal occupational design study alongside core legal curriculum. Legal educators of today are the curators for the future.